there's a social duty, really, to point these things out, because, again, a silent judge, it might occasion a justice by failing to reveal opinions, which the party then, in effect, has no opportunity to correct or modify. So we are becoming more problem solvers than adjudicators. When I say we, it's a theory that I'm developing as we go along, that judges should be more problem solver. Okay, this is a little cartoon. This is the kind of judge that we should be, right? So you're on an island, and while you were sleeping, I built it out on an abandoned sailboat, right? Who's Mr. Stupid Idiot now, right? So you took, but he solved the problem. They were looking for shelter, right? But he just wasn't looking at the list of priorities, right? All right, okay, but all right, so there you go. So what's a JSC, right? A JSC is a conference with a judge who facilitates dialogue between parties, assist them to explore mutually satisfactory outcomes, and may render an evaluative opinion if required by the parties to assist the dialogue. It's confidential, non-adversarial, cooperative decision-making process. And the key components: voluntariness, the ability of the officer to express an evaluative opinion, and the ability to facilitate cost-effective solutions of the real dispute. And when you say it sounds like a duck, looks like a duck, it's most likely a duck. Well, this is not a duck, it's not a mediation, all right? But it sounds like a mediation, but it's not really a mediation because of that evaluative component. Now, under the Code of Ethics in the Mediation Act, you would see that there's a creature called evaluative mediation. But for a mediator to conduct evaluative mediation under the Act, he has to get the written consent of the parties before he does it. So it's fine for certified mediators to do evaluative mediations, but you get written consent. We don't ask for any written consent before we do this process. And like I say, because this is not a mediation, this is a settlement conference. Talk to me.
Who determines ultimately? The sitting judge is the one who determines if a party should go to mediation or to a GSC. I know there is a cost consideration in mediation, and so is it ultimately a matter for the sitting judge to decide, well, this is preferable to mediation, where it could be more facilitative, and this one would be more preferable for a GSC, where it can be more evaluative?
The system that we envisage next year, by the new rules, which Justice Devines is here, and he could probably back me up on it, is that there'll be two stages in the problem-solving approach. As soon as the claim is filed, you go to mediation, and then later on, there will be a referral to judicial settlement conferencing. I think, is it automatically as well, or I think by consent? By consent of the parties. We do not have a provision in those rules, and we may be tweaking it, for the judge to make a decision whether this should go to mediation or to settlement conferencing. That's under the rules. But right now, as it exists, we have a voluntary system where a judge can make an order with the consent of the parties to send this file to a GSC judge. And the GSC judge will take it on voluntarily, again with the consent of the parties. Or the judge might say, this is a better case to go to mediation. The difference would be twofold: the nature of the dispute and the stage at which the dispute is at. A dispute at a very early stage, that is right after the defense is filed, we would urge that that should go to mediation rather than settlement conferencing. Let me explain why. And just to develop the point, that a judicial settlement conferencing should come later in the proceedings, after discovery, and better yet, after witness statements. The explanation here, remember Tom Calbutu was talking about the highway reroute movement. Who should be able to have the conversation? And he talked about influential people getting involved. Is this influential? Eminent. All right, we would like to think that judges are eminent, okay? So let's act on that premise. But judges come with a certain stature in the eyes of the public. First of all, you come with a whole stock of goodwill. Second, you come with the whole aspect of neutrality. Then incorruptibility. Then someone who is guaranteed to give you a fair hearing. Nobody else will give me a fair hearing except a judge. That's why they run to us. But to fight, yeah? So think about, and this has always been my problem with JSCs, think about a judge expressing an opinion on a case at a very early stage of the proceedings without seeing the documents, without seeing the witness statements, and a client walking away and saying, how that judge could say that about me? Why does he think that I don't have a case? That is a fundamental reason why a JSC should happen later in the proceedings, when the judge would have enough papers for him to make a reasoned call, a good call on the probabilities of success or not. And many cases, you would see some bad cases and it turn out to be winners, or very good cases on paper and it turn out to be losers based on the witness statements and how many witnesses you have and so on. So to give the judge that ability to make a proper evaluation, there should be some material for him to do so. Right. What was the question? That was the question.
From my personal experience, I remember the client was saying, well, why should I go to mediation when I have to pay, when I could go to JSC where ultimately there is no quote-unquote cost attached.
Yeah.
And I understand why it is we
oh, yes. So the second, yes, I'm sorry, thank you. And the second reason why you will make that decision on mediation or JSC is the nature of the dispute. If it's more relationship-based and you want to have more of a healing and a sharing of emotional content, I would prefer a mediator takes on that baggage than a judge, you know, who would be spending, because a judge and a JSC will be spending more time hearing about, you know, the whole story about my mother and this and my father and all that. And, you know, I mean, I love to do that. I love to do that. But if you're looking at an efficient system, you want to share that time of the judge between little storytelling and a little evaluation later on here. And I'll come to the flexibility of the system as well, because most of the cases that I've been doing in JSCs is really the huggy type, and you know, everybody feeling happy, and you know, and that's fine. And you really walk away with a really nice feeling when it's settled. You feel very upset if it's not settled, but that's an egotistical thing because you didn't achieve a settlement, and it's a wrong way of looking at the failure to come to an agreement. Anytime you have a conversation, that is a successful mediation or JSC. Yeah, Andrew.
I just want to comment, counter-argument to the statement by the client. You know, why should I pay for mediation when I can get a JSC down the line free? Is that surely going to pay a lawyer to get it down the line? And I guarantee you that it's going to be cheaper for you to go to mediation where you're splitting the cost with the other party than to pay your own lawyer in the hope that you win the case. But if you lose, you get to pay your lawyer and the other lawyer. So that usually kind of sorts the people out when if they say things like that, you know.
Yeah.
Or I pick up that that's what they're considering.
Yes.
First of all, you have what is called case management here. Now, if you do how case management fits in with JSC and mediation, because it seems as though you're talking a slightly different route than the OECS court system practices.
Okay, you were here all the time?
No, I usually do.
Okay. No, I didn't mean to say. Forgive me, I didn't mean to say that. No, what I started off on the premise that the judge's duties is in case management is to give effect to the overriding objective, and that is to deal with a case justly. And the whole question of how do I deal with a case justly? And the attorney's duty is to cooperate with the parties to deal with the case justly, to cooperate with the court to deal with the case justly. The JSC has evolved under that premise of how best to deal with a case justly. The Judicial Settlement Conference is a conference that's done by another judge who is not the case managing judge. All right? In your case, you have a bifurcated system in Grenada, or you go to a master and then you go to, so in Grenada is a perfect opportunity for masters to get mediation training and to develop the skills of settlement conferencing, because their case management could be a whole settlement conference. because they're not doing the trial. But
I'm curious to know how, on average, how long does it take the GSC last?
well, I'll tell you. Okay, here's this one. All right, on average, about 3 hours, 2 to 3 hours. Yeah, on average. There may be a number of reasons for that, because a lot of it is, we're still at the stage where people are learning about the process, and there's a lot of a little storytelling coming in. So we spend about an hour trying to get some emotions out of the way, and then getting the lawyers to understand that we need to collaborate and work together. That's probably another hour, and then your last hour is really that's the crunch. And actually, I had a GSC last week. I double booked the GSC with another matter. So I went to the GSC first. I said, look, I only have 10 minutes. They said, that's all right, okay. So, and everything, they started to hustle. And within half an hour, it was settled. But I'll come to the dangers of that as well. Right.
Just to pick up on the point that you left off on, at what stage is it that after the pleadings and the witness statements are therefore filed, then the GSC will take form in lieu?
Sorry?
Is it after the pleadings and the witness statements are in, then the GSC will come into being?
After the pleadings are closed,
Yes, after the pleadings are closed, because you said that there was a mandate by the Chief Justice to deal with cases from start to finish, 18 months.
yeah.
But some cases go on.
Right,
6,
right,
7
right.
years, So I'm just trying to get a timeline. Because sometimes it might take 18 months to just close the pleading.
No. Which jurisdiction? Here?
I'm involved in justice. That over 2 years,
All right,
my pleadings haven't closed.
we will have a private conversation about that. All right. Let me just. Okay, so this is our model. This is our model here. So we have the formal practice direction which we had. The request is made jointly by parties. Court encouragement is critical and is made at an advanced stage. The GSO or the registrar is the coordinator who will assign the dates and the times. The judge may convene a preliminary hearing, and I think Justice Devines, he takes that approach in most of his cases. The first hearing is a preliminary hearing to determine what are the issues, the documents needed, what briefs I will need, and who should come to the session. The GSC judge is not the trial judge for the reasons I explained. The meetings are done in CMC rooms or courtrooms. I did think about having a GSC in a hotel to make parties feel comfortable, but then the thought again of a judge going and have a meeting about a case in a hotel, and so I said let's just keep it again. In court custom neutrality, right? So average of, and then when you want to caucus, right? Anyway, so you have an average of 2 to 3 hours. The agenda is set by the judge, and then you have different styles: narrative, transformative, evaluative, and shuttle negotiation. But it all depends on the nature of the matter. This is our typical agenda. We introduce at the beginning. We have opening statements. We identify issues, understand needs. We evaluate. I'll evaluate the case. We explore some options, rationalize. We conclude. But the key here is flexibility. That's a basic, format. But we are flexible with these different stages. The GSC requires the right blend of information gathering skills, relationship skills, communication skills, problem solving skills, conflict management, and substantive knowledge. Well, substantive knowledge comes lower, way down the end of the spectrum. So what we are doing with this GSC judge, we're transforming ourselves from that to that, right? And so you come in. So in most of my cases now, even in case management, my position is, I remember some judges when I used to practice before them, they would say, okay, what is your position? That is, what's your status in the case? Now I ask, how can I help you? And that kind of throws off lawyers. Of course, but I hope the clients get the point. But anyway, in a GSC, I do not take off my jacket. I thought about it. I even thought about going in a suit. What I've decided to do is to keep my bands and my bench jacket. Again, this question of the authority, and that could work for you, it could work against you. Because again, the whole question of, you know, the judge being evaluative about my case and so on, but still you have that status. And if you have that status, you have to be careful of how you interact with the people in the room, because a wink and a gesture, you know, is going to, you know, have a more potent impact because you're a judge sending that signal. So, so one school of thought is that in the GSEs, we be very careful of the evaluation tool. What that means is that there's one school of thought in doing these judicial settlement conferences, let's be more facilitative and keep the evaluation at the back end, because evaluation is such a potent, you know, nuclear weapon, which is like, okay, this is the judge's call on the outcome of your case, and that could, you know, perhaps, you know, it can destroy the relationship even more. So that's one school, be facilitative, and the other school is be robust. And as soon as they come in, they say, well, what kind of case is this? Where are you going with this case? So that's